Hi friends, in this video we are going to deal with the article titled Admissibility of Evidence under Indian Evidence Act 1872. The author of this article is one Ms. Shivani Sharma, who after completing her LLM from IMS Unison University Dehradun and various internship programs is doing freelancing in legal field. To know more about the topic, let's quickly move on to it.
Hello everyone, I hope you all are fine. So today's topic is admissibility of evidence under the Indian Evidence Act 1872. So the term admissibility means the state or quality of being admissible or permissible. So in the legal sense, the term evidence means anything admitted by a court to prove or disapprove alleged matter of a fact in a trial. Thus, the admissibility of evidence means any document, testimony or tangible evidence used in a court of law. So, all the evidences is not allowed in the court. All the evidence is not allowed in the court, and only those evidences which is reliable and relevant are admissible in the court of law. So, evidence is introduced to a judge or a jury to prove a point or an important element in the court. So this must be noted down that all the evidence is not allowed in the court of law. Only those evidence which is reliable and relevant are admitted in the court of law. So now we are going to discuss the definition of admission. So section 17 of the Indian Evidence Act 1872 deals with the term admission. Now in general term, the admission means power or permission to enter, admittance, entrance, access, the power to approach. Now in the legal sense, the concurrence in a statement made by another and distinguishable from a confession in that an admission presupposes prior inquiry by another, but a confession may be made without such inquiry. Now a fact, point or statement admitted as the admission made out of the court are received in evidence. Now there are some principles regarding admission which are mentioned in the case Basant Singh versus Janki Singh in 1996. Now the principles are, first is it states that there remains no difference between the admission of a party in pleading and other admissions thereafter. Second is the admission made by a party in a plaint has to be duly signed and verified by that party, which could be used as evidence against that party in another suit. Now, but the same could not be termed as conclusive. Now, the third point is an admission cannot be divided into parts and can only be examined as a whole. Now, please note down that it cannot be divided into parts and can only be examined as a whole. Now, fourth point is an admission can only be read in its entire form and no statement can be taken out of the context to form an admission of a certain fact. Fifth point is an admission binds the maker to the facts of the case. Sixth is an admissibility of a plea of guilt can be determined only if the plea is recorded in the words used by the accused or the person charged with an offense. Seventh point is, for an admission to have a substantive evidence effect, it should be voluntarily in nature. Any admission which is made in ignorance of rights or under restraint in which a person is influenced, whether by lawful or unlawful forcefully, conclusion of their liability by implementation of physical enforcement, legally for the incurring of civil liability of a citizen's arrest or subrogation or illegality for the committing of an offense, of forcing a contract or of using threats cannot be considered as admission. Now these points you should be noted down clearly. Now, next point, that is, admissions are limited to being only prima facie proof, that is not needing further proof unless contrary evidence is shown or produced in the court of law. Now, and do not carry a conclusive value. Now, last point is, admissions which are clear in words of accused or the person charged with an offence are considered as the best proof of the fact submitted. Now, you should clearly note down these principles which I have mentioned in the case. Now, we are going to discuss the evidence definition. That is, definition of evidence. The term evidence is defined in section 3rd of the Indian Evidence Act 1872. Now, in the general sense, the term evidence means facts or observations presented in support of an assertion. Now, in the general sense, the term evidence can be described as anything admitted by a court to prove or disapprove alleged matters of fact in a trial. Now, admissibility of evidence in India. The law in most of the democratic country is based on the principle that is innocent until proven guilty. Now, it is the duty of the prosecution to prove beyond reasonable doubt that the accused has committed the offence. Now, circumstantial evidence, even though it is allowed in the certain cases, it is not enough to prove a case beyond any reasonable doubt. Prosecution has to rely on the material evidence to get a conviction. The material evidence must also be a one which is legally obtained to be considered as an admissible evidence. Now, section 101 to 166 of the Indian Evidence Act 1872 explains about the production of evidence and the burden of proof. Let me repeat these sections. Section 101 to 166 of the Indian Evidence Act 1872 explains about the production of evidence and the burden of proof. Now, it applies to material, documentary and evidence and also witnesses. Now, there are some evidences which are inadmissible, such as hearsay evidence, except in few circumstances. Now, it is the duty of both the parties to provide the best evidence possible to win the case. Now, evidences obtained through improper manner are inadmissible and has hindered many criminal investigations throughout the years. Now, thus, it is important to know the collection and production of evidence to utilize it to utmost effect. Admissibility means that only the facts which are relevant are admissible, and these are admissible in the court. Section 136 of the Indian Evidence Act explains which evidences are admissible and which are not. Now, the presiding officer may ask the party to clarify how the particular fact or evidence is relevant under the provisions section 6 to 55 of the Indian Evidence Act 1872 if he is not convicted of its relevance. So, technically the question of relevancy comes first, and then the question of admissibility. Now, the presiding officer has the full power in deciding whether an evidence is admissible or not in a particular case. So, with the power comes ultimate responsibility to the judge to make sure that every relevant evidence which is obtained legally is made admissible, so that the parties can obtain justice without undue advantage to one side. Now, we are going to discuss about the relevancy of fact. Section 5 to 55 of the Indian Evidence Act deal with the relevancy of facts. The main question which arises as to which fact is legally relevant and also logical in nature. Now, a logical relevant fact may not necessarily be legally relevant in the court. Now, all the facts that are to be produced in the court must be logically relevant as well as logically admissible. Now, in state of UP versus Raj Narayan, where it was shown that not all the relevant facts are admissible. Now, there is one other case, that is Ram Bihari Yadav versus State of Bihar, that is 1998 case. Now, in this case, the difference between relevancy and admissibility is explained. Now, Section 6 of the Indian Evidence Act is very important as it explains about the facts that form a part of the same transaction. The facts which are directly connected to the issue, such as motive, cause, effect, are most relevant. This is contained in Section 6 to Section 16 of the Indian Evidence Act. Now, the relevancy regarding confession and precedence is also explained in the Indian Evidence Act 1872. Now, the character of a person may also be relevant in some cases. Now, what is relevancy of admission? The term relevance and admissibility are often considered as synonym, but the legal implication of both the words are very different. Now, there is very prominent phrase to throw light on the difference between these two words. All admissible evidence is relevant, but all relevant evidence is not admissible. Now, the word relevance has a broader scope as compared to the word admissibility. Relevance is genus, of which admissibility is the species. Now, these two words can be distinguished from one another. Now, there are some points which I am going to tell you. That is, first is relevancy is when the facts are so related as to render the existence or non-existence of another facts probably according to a common course or event or human conduct. They are called relevant. Now, whereas admissibility is where facts have been declared to be legally relevant under the Indian Evidence Act 1872. They become admissible. Now, the relevancy is found on logic and human experience, whereas admissibility is found on law and not on logic. Now, the question regarding relevancy has been enunciated in Section 5 to Section 55 of the Indian Evidence Act, whereas the question of admissibility is provided in Section 56 of the Indian Evidence Act 1872. Relevancy signifies as to what facts are necessary to prove or disapprove a fact in issue. Now, whereas admissibility is a decisive factor between relevancy and proof. Fifth point is relevancy merely implies to the relevant facts, whereas admissibility implies what facts are admissible and which is not admissible. Sixth point is relevancy is the cause, whereas admissibility is the effect. In relevancy, the court may apply its discretion, whereas in admissibility, there is no scope of the court to apply its discretion. All the admissible facts are relevant, but all relevant facts are not admissible. Only legally relevant facts are admissible. Now, there are some types of evidences. Let me give you a quick review of it. That is oral evidence, documentary evidence, primary evidence, secondary evidence, real evidence, hearsay evidence, judicial evidence, non-judicial evidence, direct evidence, indirect evidence. Now, there are some conditions of admissibility of evidence in the court, and Section 20 of the Indian Evidence Act, it deals with it, and it states that the admissions of a person referred to by a party or a particular suit. This section brings another exception to the general principle of admissions made by strangers to the suit. Now, admissions made by a third party are considered relevant and are admissible when a party refers another to him for information in regard to the uncertain or disrupted manner. Now, there are two basic factors that are considered when determining whether evidence is admissible and whether it is not admissible. First is relevant. The evidence must prove or disapprove an important fact in the criminal case. Now, in the evidence, it does not relate to a particular fact. It is considered irrelevant. Now, as is therefore inadmissibility and is not permissible in the court. And second thing is reliability. Reliability refers to the credibility of a source that is being used as evidence. Now, this usually applies to witnesses' testimonies. there is a case that is KM Singh versus Secretary, Indian University Association 1992. Now in this case, it was held that section 20 is an exception to the general rule, that is admission by a party to the proceeding or his agent, which is laid down in section 18. And second is section 20 deals with the class of vicarious admissions. And third is, it states that the third person's opinion is taken into consideration when the third person is referred to be one party in the matter of dispute. Fourth point is, the third person's opinion is considered to the reason that one party in dispute approves of the third party's opinion while anticipating the other parties to inquire. I think you get my point and it will be reliable to you. Thank you. Hope you liked my video.